Hello everyone, welcome to Sunya IAS and welcome to this lecture. In this lecture, we are going to talk about a very exam-worthy, MCQ-worthy topic, that is emergency. Now, we all know that there are three kinds of emergencies in the Indian Constitution. We are going to cover all three of them through MCQs. And this is one topic that you can expect every other year, right? Because there are three kinds of emergencies and there are details about every kind of emergency that you need to remember. So let me just start this session and let me just remind those who have who are attending this session for the very first time, how this session works. See, the goal of this session and all these sessions is to make your final notes. Okay, the goal is not to revise and then leave you as it is, because mostly people do that and it doesn't help the students that much. Why I'm saying that? Because ultimately you need something which you will read in the week before prelims, right? You need something that you will read a week before pre. Okay, and through these classes, I will try that everything that you need to memorize, everything that you need to remember is there in front of your eyes when this class ends. Okay, so for instance, emergency. So for emergency, max to max, you will get a 2-pager note, right? You will get 2 pages that you will remember just before prelims. That is my goal for you. So how you are supposed to make the notes for these class? Please make notes on A4 size sheets. Don't make notes on bound registers. Okay, because there will be time when you want to remember only a few topics and you want to carry around only those few topics before your prelims. There's no point carrying the whole register. You get overwhelmed and then you want to change the chronology of the topics also. So that flexibility you need, right? And that is why I always suggest, please make notes on A4 size sheets rather than making them on bound registers. Okay? And anyway, there will not be much to write. Just attempt the question with me. And after that, the explanation part, whatever I ask you to write, just write that. Nothing more, nothing less. Your notes will be ready. Okay? And how are you supposed to attempt it? You are supposed to pause the video, think about the answer, and only then play the video and see the explanation. Okay? Be true to yourself. Chalo. Let's see the first question. Consider the following statements about the grounds for declaring a national emergency in India. The Constitution employs the expression proclamation of emergency to denote an emergency of this type. National emergency can be declared on the basis of internal disturbance or insurgency. And a national emergency declared due to external aggression is known as internal emergency. Now, let's see it one by one. Only one statement, only two, all three, or none. How many are correct? First of all, the trick has to be, find out the statement which is completely irrelevant, incorrect, and stupid. The stupid statement here is, a national emergency declared due to external aggression is known as internal emergency. This is absolutely ridiculous. This is not possible. So the third statement becomes incorrect. And don't think that UPSC will not give you ridiculous statements. Just because that statement is mentioned in the UPSC paper, we tend to think this might be true. But UPSC many times has given absolutely ridiculous statements because they want to test your patience in the examination. Okay, so this one is absolutely incorrect. Then national emergency can be declared on the basis of internal disturbance or insurgency. No. National emergency can be declared on the basis of only armed rebellion. Okay, armed rebellion, and we will just talk about it. We will talk about what happened, why armed rebellion, when was internal disturbance used, etc. We'll talk about it. So, second statement becomes incorrect. And first statement, the Constitution employs the expression proclamation of emergency to denote an emergency of this type. Yes, this is absolutely correct. I will explain to you what I mean by this. Please note it down. See, there are three kinds of emergencies. There is national emergency, there is financial emergency, and there is state emergency, which is also called the president's rule. We are right now talking about the national emergency. And when we say the word emergency, mostly we mean national emergency only. Okay, mostly we mean national emergency only, unless it is specifically written that it's financial emergency or something. So proclamation of emergency means national emergency. Now, national emergency is given in part 18 of the Indian Constitution. Okay, part 18 of the Indian Constitution. How will you remember it? You will remember part 18 because as soon as you turn 18 years of age, there is a lot of emergency to get your driving license made, to get your voter card made, and passport to chalo ho jata hai, but so many, you finally become an adult. So many emergencies to get so many documents made. So national emergency, overall the part of emergency is part 18. The article for national emergency is 352. The article for national emergency is 352. There is no way to remember this. You need to remember this by heart. Now, please understand what is national emergency. National emergency is supposed to be announced by the President of India. Okay, supposed to be announced by the President of India on the recommendation, and please start making notes side by side, on the recommendation of cabinet. Recommendation of cabinet. And here is where the word cabinet was inserted in the Indian Constitution. And if you get a question that the word cabinet is not mentioned in the Constitution, that will be incorrect. Why? Because Article 352 says that national emergency can only be proclaimed by a written recommendation by the President on the written recommendation of the cabinet. ठीक है, अभी इतना हो गया. अब इसका थोड़ा सा बैकग्राउंड भी लिख लो. This written recommendation of cabinet provision was added by the 44th Constitutional Amendment Act. Before that, an oral just recommendation by the Prime Minister of India without consulting the entire cabinet was enough to actually announce the emergency. That is how the Indian emergency, the internal emergency, was announced in India, right? And Indira Gandhi announced, the cabinet did not know that emergency was being announced. Fakhruddin Ali Ahmed was the president back then, and he actually just implemented the emergency. That is what happened. Okay. Now, Article 352, Part 18, President on the written recommendation. The written recommendation part added by 44th Constitutional Amendment Act. Now, please write down in the next line, what are the grounds? What are the grounds? Now, the grounds are, of course, one thing is war. Whenever there is war, there will be an emergency. But this particular, if there is war, this emergency, and next thing, the war and external aggression. War and external aggression. So if these two are the basis, then the emergency is called external emergency. Okay, war or external aggression, it is called external emergency. Very obvious. These kind of obvious statements also sometimes come and they confuse you. Okay, so external emergency. Now, another basis, please write this down, is armed rebellion. Okay, another basis is armed rebellion. When people take up arms against the government, it's sort of a coup-like situation. Not coup-like situation, but basically civil war kind of a situation. So when there is a civil war, when people have taken up arms, just like happened in Sri Lanka, then there is armed rebellion. Now this armed rebellion word was not always there. This armed rebellion was again added by the 44th Constitutional Amendment. Before that, the words that were there were internal disturbance. And the problem, my dear, was that it's very difficult to actually explain what internal disturbance means. Am I right? So that's why 44th constitutional amendment, again, always remember the 44th constitutional amendment as the good constitutional amendment, because whatever wrong the 42nd did, whatever wrong the 38th did, 39th did, the 44th tried to revoke that wrong. Okay, so that is there. Then another thing, even if a war or external aggression has actually not happened till now, even if there is a threat of war or external aggression, even then the president can announce emergency. So you can get a statement that the pronouncement of war is necessary to announce an external emergency. No, it is not necessary. Even a threat of war can lead to announcement of emergency. Okay, so that is there. Then another thing, emergency can be imposed even if another emergency is already enforced. Please listen to me very carefully. Even if another emergency is already in force, so even then a new emergency can be imposed. Just look at it through an example. For example, there was an external emergency. There was an external emergency which was going on because of the 1971 war, right? 1971 Indo-Pak war, and the creation of Bangladesh and everything. So external emergency was already going on. The second emergency that happened in India. After that, when Indira Gandhi announced an internal emergency in 1975, the external emergency was already running. Okay, so this actually has been introduced, and this has been introduced by 38th constitutional amendment. So what you can simply write is 38th constitutional amendment, emergency over emergency can be imposed, right? Always have very short, very crisp notes that you can revise at the end of your preparation, not at the beginning of your preparation. Okay, then another thing when it comes to the national emergency, there's a lot to talk about national emergency, so just keep on making the notes. Okay, now president can impose national emergency for either the whole country or even a part of a country. So if in any part of our country actually there is an emergency like situation, like in Manipur it was happening, so it was possible for the president to impose emergency just in that state and nowhere else. Okay, this provision was also added later. This provision was added by 42nd Constitutional Amendment Act. This is how, and this is why you need to remember such things, because UPSC is now going into the deep details of amendments, deep details of exact information that you need to know, my dear. Okay, so that is there. This much I hope you have written. Okay, then one thing that happened, there was this debate that whether the national, the announcement of national emergency is immune to judicial review. If the president has announced national emergency, is it immune to judicial review? So just write national emergency immune to judicial review. Immune to judicial review. And then make this kind of a chart. Right? 38th Constitutional Amendment Act said that yes, it is immune to judicial review. That means if the president has actually announced that there's going to be an emergency, you cannot take that decision to the courts. There is an emergency and it has been announced. Simple. But again, which is the good amendment that we have? It is the 44th Constitutional Amendment, which said no. It cannot be immune to judicial review because judicial review is a part of our basic structure. Please remember, basic structure doctrine had already been created in 1973 by the Kesav Nanda Bharti case. Okay, that is there. So now the basics you have written. Now please see that how an emergency will actually be proclaimed. So it is very clear that who will proclaim the emergency? It will be the president. But does that mean that president can do it on by herself? No. So can happen only on the written recommendation of the cabinet. But for such a big thing, you require parliamentary approval, right? So just write parliamentary approval. Parliamentary approval, first thing, will happen by a special majority in both the houses. Okay, please write this. Special majority, and in bracket you write both the houses. This is one thing. Now how? Within what time? It is a very good thing that for the emergency provision, there is a time limit that has been given. Earlier, the time limit was 2 months. So within the proclamation of emergency, within 2 months, the emergency had to be approved by the parliament, both the houses. Otherwise, the emergency will cease to exist. And what is the purpose? The purpose is that there should not be any authoritarianism, right? So there was earlier, it was 2 months. Then this 2 months was scrapped. And again, by the good amendment, the time period was reduced to 1 month, that is 30 days. So now, if and when an emergency is proclaimed, within 30 days, it has to be approved by both the houses of parliament by a special majority, not a simple majority. Please understand. Another thing. There is a possibility that while this particular thing is happening, while the emergency has been proclaimed, the Lok Sabha is not in session. There is a possibility, strong possibility, right? No issues. Whenever Lok Sabha will be in session, and it is written in the constitution that 6 months cannot elapse between 2 sessions of the Lok Sabha. So minimum there have to be sessions in the Lok Sabha in such a way that there cannot be more than 6 months gap between the sessions. So whenever the Lok Sabha meets again, within 1 month of that time period, the emergency has to be proclaimed or it will cease to exist. Provided that Rajya Sabha should have passed the emergency with a special majority in that meantime. Okay, when the Lok Sabha was not in session. Okay, I hope you understand that. I hope there is no issue. So this is the parliamentary approval. Okay. Now, consider the following statements about the effects of national emergency on fundamental rights. Article 19 is automatically suspended when a national emergency is declared. Article 358 specifies that Article 19 can only be suspended during a national emergency declared on the grounds of war or external aggression. And proclamation of emergency can suspend the right to move to any court for the enforcement of fundamental rights. See here, what do you think is the correct answer? First, find out the absolutely incorrect statement. Do you see an absolutely incorrect statement over here? No. There is no stupid statement. There is no absolutely incorrect statement because we know, even if we don't remember, we know that there is some effect of emergency on the fundamental rights. So we will see it statement by statement, what it means. See the first statement. Article 19 is automatically suspended when national emergency is declared. This is actually correct, right? Article 19 is freedom of speech and expression. And Article 358 says that Article 19 will be suspended automatically when national emergency is declared. So the first statement is absolutely correct. In continuation of this, see the second statement. Article 358 specifies that Article 19 can only be suspended during a national emergency declared on war or external aggression. See, earlier it was not like that. Okay, earlier, even if for internal disturbance the emergency was announced, then Article 19 was automatically suspended. But again, the good amendment came to our rescue, and it was through the 44th Constitutional Amendment Act that we actually have this provision. Because see, try to understand the logic behind this. The logic behind this is very simple, that if somehow the executive has been able to actually implement the emergency and the rights of people are under danger, are endangered, then it cannot happen for armed rebellion, right? Internal emergency के लिए नहीं हो सकता ये. If there is a war or external aggression, then you need your people to be quiet so that you can handle it. Okay, but if your people are against you for some reason, then you cannot just take away their Article 19, right? So that is why by the 44th Constitutional Amendment Act, this was enacted, that only for external emergency there will be automatic suspension. Then third statement is also correct, and this is actually written in Article 359, that if there is proclamation of emergency, then the president can actually enforce an order which says that these fundamental rights are not going to be available to any of you. Okay, now please understand, this can be a little complicated. See, 358, there is automatic suspension, right? Please write down with me. Write down the heading, small heading, effect of national emergency on fundamental rights. Okay. Article 358 says automatic suspension of Article 19 in case of external emergency. And this external, you just write down a bracket and write 44th Constitutional Amendment Act. Right? 44th was the good amendment. It tried to just revoke a lot of bad things that had happened. Then please write Article 359. 359 says that the presidential order shall suspend the fundamental rights which are mentioned. Not all rights will be suspended. And this can happen for internal or external emergency. Internal or external emergency, both. In both the cases, president can implement. Now, again, here is a caveat, and again, the good amendment comes to our rescue. The good amendment, the 44th Constitutional Amendment, said that you can suspend any right, but you cannot suspend Article 20 and Article 21. Okay, you cannot suspend Article 20 and Article 21 because they are the lifeblood of liberty. This happened when this right to life was endangered because of the sterilization programs and whatever happened during the emergency. You all are broadly aware of it. So my point is that 44th Constitutional Amendment clearly said that you can suspend any article, including Article 32, that is right to get your constitutional rights safeguarded by the Supreme Court, but not these two. And there is always confusion between 21 or 22 or 20 or 21. It is 20 or 21. 20 and 21 both. Okay. So 20 is about the three principles. Please remember with me. No ex post facto. You cannot be arrested for something that was not a crime when you did it. No double jeopardy. You cannot be jailed for the same crime twice. And no self-incrimination. You cannot be a witness against your own self. It is very clear why this is a caveat, right? Because if these are suspended, anyone who is running the government will be taking out anything and everything on the people of the country, right? So that is there. Please write this down. Let's move on to the next question. Consider the following statements regarding the declaration of a national emergency. The 44th Amendment added the provision that made a declaration of national emergency immune to judicial review. According to Constitution, national emergency can be challenged in court on the grounds of malified or the fact that they are based on wholly extraneous and irrelevant grounds. And a proclamation of national emergency can be extended indefinitely by a presidential order. How many statements do you think are correct? See, find out the first incorrect statement. First of all, the third statement is absolutely incorrect because it can be extended indefinitely but only 1 year at a time. Okay, it can be extended only 1 year at a time. Okay, so this one is incorrect. Then go for the first statement. We all know that 44th constitutional amendment is the good amendment. Why will it make the national emergency immune to judicial review? It will bring it back under judicial review, right? So this again becomes incorrect. And according to the constitution, because of this, according to the constitution, this statement is incorrect. Otherwise, this part is correct, that national emergency can be challenged in courts on the ground of malified, etc. But this was not given in the constitution. This is actually given by the Supreme Court in the Minerva Mills case. Please write this down. In the Minerva Mills case, so if you remember, the 44th constitutional amendment said that it is under judicial review, and then Minerva Mills case 1980 says that these are the grounds on which it can be challenged. What are the grounds? That it is malified, wholly extraneous and irrelevant facts, etc., etc., etc. Okay, I hope you understand. So Minerva Mills case has also commented upon the national emergency. So I hope you understand. Okay, now write a few more facts. Okay, let's just write a few more facts. See, the thing is, there are some effects that happen of effects of the national emergency on Lok Sabha. And this happened during the internal emergency. So I'm telling you. And this is important for your examination also. Whenever emergency is in force, you have to see that Lok Sabha can be extended. Okay. Lok Sabha can be extended. But what is the time period for which it can be extended? It can be extended by a period of 1 year at a time. Okay. So let's say the Lok Sabha had to be dissolved. Let's say in 2024 it will be dissolved, right? And it is going to be dissolved. So if by chance at that point there is an emergency running, then there can be a resolution passed saying that Lok Sabha will be carried forward for 1 year, but it can happen beyond its normal term for 1 year at a time, not at one point for infinite time period. Okay, but as soon as the emergency ceases to operate, within 6 months, this extension will come to an end. So within 6 months, there have to be elections again. Now please make this very crucial difference in front of you. On Lok Sabha, this is the impact. Okay. On Lok Sabha, this is the impact. If we want to extend the emergency itself, then what we do? We can extend the emergency by 6 months at a time. 6 months at a time. and infinite times, right? So every 6 months, both the houses of parliament will have to pass the continuation of assembly again by special majority, both of them, and then that particular order will stay on for 6 months, and then again after 6 months they have to pass this order, and this keeps on happening infinitely. That this can happen. Same with Lok Sabha, but the period is 1 year at a time, and as soon as the emergency ceases to exist, the Lok Sabha extension will end within 6 months. So within 6 months the elections have to happen. I hope this is very clear to all of you. Okay. Now, let's just move on to the next question. Consider the following statements regarding President's rule in the Indian Constitution. The power given to the central government under Article 356 is unique in liberal democratic constitutions, as it is completely absent in North American constitutions. Then both India and Pakistan borrowed Article 356 from the Government of India, and B.R. Ambedkar assured that Article 356 would remain a dead letter and not be used. So, how many of the above statements do you think are correct? See, the thing is, you have to find the completely incorrect statement first. Is there any completely incorrect statement in this particular question? Not visibly. Okay, so let's go question by question. The power given to central government under Article 356 is unique, absolutely, in liberal democratic constitutions, and it's completely absent. Now, this completely word can confuse you, but it is actually correct. And how you can arrive here? Because North American constitutions are completely federal constitutions, right? American constitution is completely federal constitution, and that is why there is no point of having a president's rule, or more than a president's rule, it's a governor's rule actually. So that cannot happen, and that is why this statement is correct. It is unique to India. And yes, even the second statement is correct. This can be a new piece of information for you, that both India and Pakistan borrowed Article 356 from Government of India Act. And even the third statement is correct. Dr. B.R. Ambedkar assured that 356 will remain a dead letter. Even this is correct. So here all three statements are correct, and now we will start the President's rule. See, President's rule. Given again in part 18, but the article is 356. Okay. Now, please make a sort of a triangle, and we will also do it when we do center-state relations. Please make a sort of triangle, which I'll tell you why I am telling you this, so that you can have a quick revision. There is Article 256. Then there is Article 365. And then there is Article 356. See, Article 256 says that it is the executive responsibility of states to comply with the executive directions of the center. So whatever the center has said under 256, it is the duty, the responsibility of the states to follow what the center has said. Okay. Now 365 says that if the state does not comply with the directions of the union, then it shall be lawful to consider that the state's government cannot be run according to the provisions of constitution. Okay, so 365 says that it will be lawful to assume that if Article 256 is violated, then the government cannot be carried on according to constitution. And then comes the mega article 356, which says that if there is the breakdown, if there is constitutional breakdown, then president's rule can be imposed. So the trio the trio of this particular article 356 is very interesting to note, and this is the reason why we say that our constitution is a unitary constitution. It's not a completely federal constitution as such. Okay, that is there. So 356, 256 and 365 I told you. There is another article which is just before 365, that is article 356, that is article 355. 355 talks about the duty of the union. And what is the duty of the union? To ensure two things. One, that the government is going on according to the constitution. Please stay with me and see what I'm saying. One, that the government is going on according to the constitution, that the union has to ensure. And one is about the safety of the state in that sense, safety, security, etc. So on the basis of these articles, then the article 356, which is the president's rule, which will actually sort of violate the federal provisions of the constitution and just terminate the government of the state and give the powers to the president. That can happen. Okay. So just understand this. Let me explain this to you, that on what grounds does this happen. So if we were just to revise and just learn about it, then what are the two bases on which the president's rule can be imposed? One is the basis when the government of the state cannot be carried on in accordance with the constitution. Government of the state cannot be carried on in accordance to the constitution. This is one condition. The second condition is that the state has failed to comply with the directions of the union. So state is not complying with the directions of the union. This can be another issue. Okay. So there are two issues on the basis of which there can be president's rule in a particular state. Now, another thing that you need to write. Governor will send a report to the President of India saying that an emergency should be imposed. But does that mean that only on the basis of governor's report the emergency can be imposed? No. Even without governor's report, the emergency, the president's rule can be imposed. So, governor's report not mandatory. Governor's report not mandatory. Please remember. Okay. Once you've written that, also write how the president's rule is supposed to be approved. How the president's rule is supposed to be approved. So, let's say the president has just proclaimed the president's rule. Now, it will go to the parliament, right? The parliament has to approve it by a simple majority. Please make sure this is a difference. By a simple majority within 2 months of the proclamation. Okay. So, for the national emergency, also it was earlier 2 months, but it was reduced to 1 month by 44th Constitutional Amendment Act. But for the president's rule, it has not been reduced. It is still the same. It will be there valid till 2 months, and if in 2 months it is not approved, it will be null and void. Okay. What if the Lok Sabha is not in session? Just write, if Lok Sabha not in session, then within 30 days of reassembly, not 2 months, but 30 days, that is 1 month. Within 1 month, it has to be approved by the Lok Sabha. And in the meantime, it has to be approved by the Rajya Sabha. Okay. I hope these timelines are clear. Another thing, the continuation. What about the continuation? Like we know that for the national emergency, we can continue it for every 6 months, right? Even here, we can continue it for every 6 months by a simple majority. We means parliament can continue it. But maximum amount of time is 3 years. Maximum amount of time for which it can be extended is 3 years. It cannot be extended more than 3 years. Okay. Even in this, there is a caveat that has been added by the 44th Constitutional Amendment, that is the good amendment. 44th Constitutional Amendment has done a lot of good things, and here also it has done this good thing, that if it is being extended beyond 1 year, if it is being extended beyond 1 year, some conditions have to be fulfilled. What are those conditions? Those conditions are that number one thing is that in the entire country or in some part of the country, national emergency should be in force. See, because understand the logic behind it now, that you cannot be aimlessly just continuing the president's rule in a particular state without any thought, right? You have to make sure that there is a reason why you are continuing this. So one reason can be that national emergency is in force. The second reason is that Election Commission of India has ratified that elections cannot be held in that particular state. Elections can't be held in that particular state. These two things have to be achieved over there. Now, how can it be revoked? How can it be revoked? It can be revoked by the president himself or herself. And no proclamation or no approval or nothing is required. Okay? This is something that you need to write about the president's rule. Now let's move to the next question and solve some more aspects to it. Consider the following statements about the president's rule. The president can impose the president's rule in a state only on the ground that there is a failure of constitutional machinery. Then during the president's rule, the state assembly is automatically dissolved. And the president's rule can be imposed in a state without the governor's recommendation. How many of the above statements are correct? First of all, find the incorrect one. What is the incorrect one? We know the first statement is incorrect. Because even when the state does not comply with the directions of the union can impose this particular aspect. Okay, this particular president's rule. So this particular statement becomes incorrect. Now, this also I have told you that this is correct, that governor's recommendation is not actually compulsory. The president can even announce the president's rule without the governor's recommendation as well. So this is correct actually. Now the second statement. This is actually incorrect. And now that you know the answer is one only, we'll go on to the explanation of it, that what are the effects of president's rule. First of all, you would know, and this is very commonsensical, that the effects of president rule will just be restricted to that particular state on which the president's rule is applied. This is commonsensical knowledge. But you have to be very careful about what are the effects. First of all, the thing is that the executive of the state. What is the executive? The government of the state. I'm not saying the legislature. The government is a narrower part. Okay. So the government of the state, that is the cabinet of ministers, the cabinet of ministers shall be removed. Because the meaning of president's rule is that the government of the day is not able to take care of the state, and that is why the president has to intervene, and that is why the executive, the council of ministers will be removed. Will the state legislative assembly be removed? Not necessarily. Not necessarily. It can be temporarily suspended. Okay. Basically, without the state legislative assembly, without the council of ministers, the state legislative assembly will anyway be dysfunctional. Because to advise the governor, you need the council of ministers. So anyway, the state government and their functions, now that the state government is going to be suspended and removed, the state government, the functions of the state government shall be exercised by the governor. And that is why it is also called the governor's rule, right? It shall be exercised by the governor. who shall of course not be advised by the Council of Ministers, because Council of Ministers are not there anymore, shall be advised actually by the Central Council of Ministers, advised by the President. That is why we say that the President rule actually transforms the state structure from federal to unitary. Okay, from federal to unitary. So Council of Ministers is removed. State governor will carry on the administration, and President can choose whether the legislative assembly shall be dissolved or not be dissolved. That is not necessary. But let's say if the legislative assembly is dissolved, then what? Let's say the president chooses that the legislative assembly has to be dissolved. So if state legislative assembly is dissolved, don't ask me what if the state legislative council is dissolved, because legislative council never gets dissolved. It is a continuing chamber. So the powers of the state legislative assembly shall be transferred to the parliament. So powers transferred to parliament. Okay. The executive powers have been transferred to the executive, the governor. The legislative powers have been transferred to the parliament. Parliament can delegate those powers. Parliament can give those powers to the president. Okay. Parliament can give those power to the president. So the power does not automatically go to the president. The parliament gives the power to the president to actually act as the legislative body also. So the president effectively can make the laws as well. Basically, the parliament becomes the state legislative assembly for that particular state. Okay. So president will also have ordinance making powers. President will also have ordinance making powers. Okay. And overall, whenever a law is being made during the president's rule, it shall continue to remain in operation. The law shall continue to be in operation even after the president's rule has subsided. Okay, this is very important. This is very MCQ worthy, that any law that has been passed by the parliament or by the president for this particular state shall be continue to be in existence. Okay, I hope you understand that. Next question. I hope you have written everything that I have told you. The Constitution imposes an obligation on the Union to protect every state against external aggression and internal disturbance. The manner in which the Union must protect a state is explicitly outlined in the Constitution, and Article 356 provides provisions in case of the failure of constitutional machinery in the states. Now, which statement is absolutely correct over here? Anytime the Constitution will never talk about the exact manner in which this particular thing is to be done. So never explicitly it will be having the manner. So this becomes incorrect. Constitution imposes an obligation on the Union. Yes. Article 355 places an obligation on the Union to protect state against external aggression and internal disturbance, and this internal disturbance continues to remain internal disturbance other than armed rebellion. And 356 provides provisions in case of failure of constitutional machinery. Yes, this is exactly what 356 does, and when this happens, then there has to be president's rule with or without the report of the governor. Another very thing that you need to understand, a very important thing that you need to understand is that president can have the power while a president's rule is enforced. President can have the power of any authority of the government, of the legislature, but cannot have the power of high court, power of judiciary basically. So president for that particular state can become the government, can become the prime minister, can become the chief minister, but cannot become the judge of these particular courts. Fine. I hope you understand this. That this is what separation of power means, right? This is what separation of powers means. Consider the following statements about the judicial review of proclamations of state emergency. Please read this very carefully. Constitution has provided that validity of the proclamation issued by the President is subject to judicial review. When a prima facie case is made out challenging the proclamation, the burden is on the Union government to prove the relevance of the material, and the court can interdict the issuance of the proclamation or the exercise of any other power under the proclamation. How many of the above statements are correct? Now, find the incorrect statement first. The Constitution very rarely will say the exact words judicial review and the fact that something is there under judicial review. It is only under Article 13. Even there, judicial review word is not used, but it is written that any particular law which is not in conformity with this part shall be null and void. So, first statement is very well incorrect because Constitution does not provide for the judicial review. It is the courts which have said that yes, it can be. Now, second one, you have to correct by your common sense, because whenever a case is there, let's say in any state, the president's rule is imposed and the union is asked, why did you impose it? It will of course be on the union to prove itself that there was a case for the union to impose the president's rule. So this becomes correct, right? You have to develop this commonsensical mentality also. And the court can interdict the issue of proclamants. Yes, court can do anything. Just see it like that. Court can actually do anything. So, only two statements are correct. Okay. Now, let's come to the financial emergency. See, financial emergency. See the question first. Which of the following is true? Once approved by both the houses, a financial emergency continues indefinitely until it is revoked. The proclamation of financial emergency automatically expires after 6 months if not renewed by the parliament, and the financial emergency can be extended for a maximum period of 2 years at a time. Now, see if there are any statements which are contradicting each other. See if there are any statements which one statement is saying one thing and the other statement is absolutely saying something else itself. So there are two statements which are contradicting each other over here, A and C, 1 and 3 basically. One is saying that it continues indefinitely and third is saying it can be extended for a maximum period of 2 years at a time. Both cannot be correct. So you need to know which is correct. Actually, it is the first statement which is actually correct. Okay. So this one is incorrect. And second statement, the proclamation of financial emergency automatically expires after approval of 6 months. No, 6 months is a lot of time. Even here it is 2 months. Okay. So regarding emergency, just remember that only for national emergency, the condition is now 1 month. Otherwise, for the president's rule and the financial emergency, the condition remains to be 2 months. Please make a note for financial emergency, the notes which you are going to remember in your final times. So financial emergency, again part 18 and article is 360. 360 is a very easy article to remember. 360 degrees you will be able to remember. So again, the president will declare the financial emergency when the financial stability or credit, what is the ground? You need to know the ground. It is written in the constitution. When the financial stability or credit is under threat. Financial stability or credit of India is under threat. So technically during the 1991 crisis, we should have been imposing the financial emergency, but we did not, which was a great thing. Okay. Then it has to be approved by both the houses of parliament by a simple majority, and once it is approved it continues indefinitely. This you have already noted down by now, so no need to renew it every 6 months. It continues indefinitely, but here the approval has to be done within 2 months. I hope you understand. So there is no maximum period for which the emergency can be imposed. There is no need to renew it again and again, and it can be done by simple majority. Revocation, again, it can be revoked by the president, and there is no parliamentary approval that is required. Now, of course, when financial emergency is proclaimed, then the money has to be used very carefully, and that is exactly what happens. Even the judges of Supreme Court and High Court, the executive authority of the center, that is the president, can actually declare that the salaries of the judges and judiciary can also be changed. So this is something that is a doubtful thing for most people, that whether Supreme Court and High Court judges salary can also be reduced. It can be reduced. See, entire country is under threat, right? So even the judges have to suffer. That is the thing. So we have done the topic of emergency. You have the notes that you require for your final revision, and whatever you need to add on to the notes, please add on in a very crisp manner. Don't write mains centric things in your prelims notes, because trust me, you are going to cherish these notes 1 week before the prelims. That is when you will be revising everything. So let me tell you a little bit about this course. Revise Entire Prelim Syllabus through 3000 plus MCQs is the name of the course, and very self-explanatory. We are going to cover modern history, polity, geography, economy, art and culture, current affairs, ancient and medieval history, environment, ecology, and science and technology. There is all the subjects required for your prelims examination through 3000 plus MCQs, and we are going to do it in this format. I am going to take all the subjects, and if you are interested in streamlining your preparation in this manner through MCQs, then please contact on this number or go to this website and you can find out more about it. That's all for this class. I hope you derived some value out of it. I will see you all in the next one. Thank you for watching.